welcome to this week's Mayor Brown's Quick Insights on Congressional Investigations. I'm Andrew Olmem, the former Republican Chief Counsel at the Senate Banking Committee. I'm joined with my colleague, Michael Levy, a white-collar defense attorney. This week's question is, what are the biggest mistakes made in congressional investigations? Michael, what mistakes have you seen in your career?
Well, unfortunately, there are almost an infinite number of mistakes that have and can be made in congressional investigations. The ones that are most obvious are things like destroying documents or making false statements to investigators. Those would be the same mistakes in any government investigation. And I always tell my client that rule number one in any government investigation is don't flunk the investigation. But with respect to the specifics of congressional investigations, I think that the biggest mistakes that are made there really come down to failing to fully account for both parts of the process, that is, congressional and investigations. And so if you just treat a congressional investigation like it's a typical traditional legislative interaction with a congressional committee, you're not really taking into account the very particular dangers of a government investigation. So, for example, more so than you would in a typical policy situation, you need to make sure that company executives are very well prepared to make statements to congressional investigators, whether they are under oath or not under oath. You need to make sure that the company's attorney-client privilege is protected. You need to recognize that the implications of negotiating the scope of a document production are very significant when you don't know what documents will ultimately wind up falling within the scope you've negotiated. And you need to recognize that once you commit to providing a certain category of documents to congressional investigators, they're going to hold you to that commitment just like DOJ, SEC, or other government investigators would hold you to that commitment, no matter how embarrassing the emails that you wind up finding out may turn out to be. On the other hand, you can make a mistake by treating a congressional investigation just like a traditional DOJ, SEC, or regulatory investigation, and that fails to account for the very specific political and reputational risks that you face when you deal with Congress. Congress has a nearly unparalleled ability to access and effectively take advantage of the media as a tool to achieve its ends. So embarrassment, public shaming are very common. There's no secrecy like there is under Rule 6E for grand jury investigations. There's no judge who's sitting at a congressional hearing who is ruling on objections to unfair, misleading, or objectionable questions, no matter how unfair, misleading, or objectionable those questions may be. And if you antagonize staff or you antagonize members, they can leak materials, they can attack you in the press, they can inflict very significant reputational harm in a forum where they have an unbelievable home court advantage. And you can see that by having, watching CEOs come and testify at hearings where they testify in a way that very carefully protects the company's interests in litigation or in enforcement matters, but winds up getting lambasted by members who criticize that approach. And then there's so much blowback that a chagrined board of directors says, I'm sorry, you're going to have to resign. So congressional investigations are unique. They require a very unique collaboration among in-house counsel, government affairs executives, and outside counsel with very specialized expertise in congressional investigation in order to find a way to thread that needle, to protect the very significant legal interests that the client has while also minimizing reputational damage. And you may not be able to eliminate all risk, but what I find is the biggest mistakes are when people pay too little attention either to the fact that we are dealing with Congress or the fact that we're dealing with a government investigation.
I think that's exactly right, Michael. And having seen attorneys who emphasize one over the other during my years on the Hill, I think having that balance is exactly right. And in particular, also remembering that Congress, unlike the executive branch, has the speech or debate clause, which protects members from disclosing any information they received in the congressional record or in a committee hearing or on the Senate floor. So even if you think your information that you're providing to congressional investigators is protected, the Constitution says otherwise. And it's important to always remember that the speech or debate clause will apply. Well, that's this week's Quick Insights on Congressional Investigations. We'll see you next week.